Thank you, Mr. Chairman, and thank you, gentlemen, for being here. I have two questions. First is I'm going to go back to indemnification. Just a simple question. With the indemnifications that these gentlemen, that they signed, was that a standard practice for all employees when they were hired? And then the next question would be, was this indemnification changed at any time during their employment?
It was standard as part of our regulation. I'll have my counsel provide further detail.
Both the bylaws of the corporation address this, and the individuals had contracts. Ms. Spencer did not have a contract, but agreed to an indemnification repayment contract, which was a standard contract in 2004. So this dates back to that time. They've not been modified.
Okay.
Is that any more from Fannie?
That's correct. All officers and directors receive indemnification and advancement contracts currently, and that's been the practice since 2004.
Thank you. Next question, we're going to go back to reasonableness, because quite frankly, reasonableness is in the eyes of the payer. And my biggest concern is going forward, and it's really, I'm looking going forward, is how we make sure we mitigate and minimize taxpayers' expense. If Mr. Raines was here today, I would really ask him if he'd be willing to voluntarily pay his legal fees going forward, because then we would really determine what reasonableness was or wasn't. But since he's not here, I'm going to ask the question to you. And I know you've talked about a panel outside of your organization as to the panel is who you look to for reasonableness. But the question is, reasonableness, again, is in the eyes of the beholder, the eyes of the payer. So my question to you is, what are the guidelines that this panel was looking at when it comes to reasonableness? Quite frankly, as a business owner for the last 28 years, I pretty well have determined what unreasonableness is in a courtroom when you see 10, 12, 14 attorneys on the other side. So is there reasonableness standards that were given, or are you relying 100% on what this panel says? And I would ask this next question as a follow-up. As the director of the organization, you could also determine reasonableness and overrule their opinion. I would ask that question too.
Yes, sir. So I'll begin, but others may want to contribute. As you noted, the first line of defense here, the first test of reasonableness, the first level of review is the outside firm retained by Fannie Mae with expertise in this area to review line by line the submissions that are made for advancement of fees. The next line of review is the Fannie Mae legal department itself, overseeing the activities and the expenses that are involved. The next line of review is FHFA's legal department that is monitoring this activity and is doing so with the benefit of our own outside counsel who's aware of the ongoing major litigation activities. So those are the various reviews that are in place. But I will say, in fairness to this hearing, and I think that this hearing that the chairman is bringing is raising important questions, and I respect that. And I will say that FHFA is committed to redoubling its efforts of review here, even though I am not aware of any evidence that there have been unreasonable payments made. There are reasonable questions being asked, and we will take additional steps to monitor this. And as I've already said in response to a question from a previous member, I intend to file with the judge in the particular case my testimony so that he's aware of the concerns that have been raised here.
Yes, Congressman, we take this very seriously, our responsibility to manage the expenses of the company and including the legal fees. I'd like to actually ask Mr. Myopoulos to walk through the process and what the expectations are as it relates to these expenses.
Congressman, we retain a company called Legal Cost Control, which is frankly the leader in this space, is really one of the most respected invoice and audit firms in the country with over 20 years of experience. They were selected by the bankruptcy courts in some of the largest matters in history, including Enron, WorldCom, and Adelphia, to review the legal fee applications of lawyers in those cases. They analyze over $60 million in monthly billings for corporations such as Microsoft and Pfizer and Walmart, and so they are very experienced at this. They have a set of guidelines that they've developed with us that are 13 pages long and quite detailed They distribute those to all the law firms involved, require them to acknowledge that they have received them and read them and that they will abide by them. And then they review each one of these invoices line by line and raise questions where they think that the fees are not appropriate. That is in line with what similar lawyers charge for similar matters. I think in the context of this matter, the question of reasonableness doesn't mean that we always end up with a small number, okay? We clearly are spending quite large amounts of money on this matter, but this is a case that involves billions of dollars of potential liability, billions of dollars, and I have been doing this kind of work myself for 25 years now in my career, and when you look at what it costs to defend a case such as a WorldCom or an Enron or an Adelphia or this matter, the amounts of money we're talking about are comparable in terms of what you see. These are enormously expensive, time-consuming matters with very complex legal issues. The lawyers who get paid a lot of money for their skills and experience and expertise in these matters. And so I don't mean to suggest by saying that while we think that the fees that have been paid are reasonable, that we're happy to pay them. We clearly would prefer not to, but they are consistent with what lawyers who do this kind of work in this kind of matter get paid. And that's really the test that legal cost control is applying as it goes through this process.
Thank the gentleman. Capiano.